Episode 4, The Child Who Refused Contact. And today's question is this: what happens when a child simply refuses to go to contact? Not misses one weekend because they are ill, not asks to change a midweek visit because they have outgrown the routines, such as last week, but refuses to go at all. There is a court order. Dad is waiting outside. Mum says she is encouraging the child. The child is upset and contact does not happen. Then it happens again and again. So who is responsible? Is mum breaching the order? Is the child old enough to decide? Or is something else going on that the court needs to understand? And if you were the judge, would you enforce the order, investigate further, or change the arrangements completely? That is today's case. And today, you be the judge. Welcome back to Family Court, You Be the Judge. This is the series where I give you a family court scenario, you decide what you would do, and then I tell you what happened next. But before we get into it, the usual disclaimer. These are composite family law scenarios based on issues commonly seen in the family court. They are not about any identifiable person or family. They are not legal advice. They are designed simply to help people understand how these decisions may be approached in England and Wales. I am a Mackenzie friend, not a solicitor, and the views expressed here are my own. So, from the last episode, we looked at a child who started resisting midweek contact. But that scenario was different. In that scenario, when the court looked more closely, the issue was not really that the child was rejecting a parent. The child had got older. School had changed. Homework had increased. Friendships mattered more. The midweek arrangement that might have worked when he was younger had simply stopped working in real life. That is a very common issue in family court. Sometimes an order is not being ignored. Sometimes a child has just outgrown the arrangements. But today's scenario is different. This is not about tweaking the midweek contact. This is not a child saying, I didn't want to go on a Wednesday after school anymore. This is about a child refusing contact entirely. The order said the father should spend time with his daughter every other weekend. Quite common. For 6 months it worked. Then, one Friday, she refused to go. The next fortnight, she refused again. Then again. So this scenario raises a much sharper question. When a child refuses to go at all, what should the court do then? So the facts. A final order had been made after a lengthy court case. The order said that the father would spend time with his 8-year-old daughter every other weekend. For 6 months, everything worked well. No major problems. No missed weekends. No serious arguments at handover. The case had finished. The order was in place. And everyone probably thought that was the end of it. Then, one Friday, everything changed. The child refused to go. Mum encouraged her. Dad arrived, the child became upset, and eventually contact did not happen. The following fortnight, the same thing happened again, and then the parents were back before the court. Dad said Mum was breaching the order. Mum said she could not physically force an 8-year-old child into a car. Dad said she was not trying hard enough. Mum said forcing the child would cause distress. So here's the question. If a child refuses to go, who's responsible? The parent, the child, or neither? Should the court enforce the order? Should it investigate further, or should the arrangements change? Before I tell you what happened, I want you to pause and sit in the judge's chair for a moment, because this is one of those scenarios where both parents can sound reasonable. From Dad's point of view, there's a court order. He's been through a lengthy court case. He has probably spent months, possibly longer, trying to secure regular time with his daughter. The court has listened to the evidence. The court has made a final decision. The order says alternate weekends. And now suddenly that time is not happening. So you can understand why Dad says, well, what was the point of getting an order if it could just be ignored? And that's a fair question. A court order is not a suggestion. It's not a rough guide. It's not something that a parent can follow only when they feel like it. But from Mum's point of view, She has an 8-year-old child in front of her who is upset and refusing to go. She says she is encouraging her. She says she is speaking positively about Dad. She says she is not stopping contact, but she also says, what exactly am I supposed to do? Pick her up, carry her outside and force her into Dad's car? And that's also a fair question. So before we go any further, what's your instinct? Is Dad right? Is this a breach of the court order? Is Mum right? Is she being asked to do the impossible? Or would you want to know more before deciding? Put your first instinct in the comments now, and then see whether you still agree with yourself by the end. Dad's position was straightforward. There is a final order. The order says alternate weekends. For 6 months, the court order has worked, and now the contact has stopped. From his point of view, this cannot be allowed to happen. He says Mum is breaching the order. He says she is not trying hard enough. He says an 8-year-old should not be allowed to overrule a judge. And he says his relationship with his daughter is starting to slip away. That last point is important because in family court, delay can change everything. If a child misses one weekend, that may be recoverable. If a child misses several weekends, the anxiety can grow. The distance can grow. The parent who is not seeing the child becomes more frustrated. The parent the child lives with becomes more defensive. The child feels more pressure. And the longer it goes on, the harder it can be to restart. So Dad says the court needs to act now. Not in 3 months, not after endless back and forth, now. Because otherwise, he says, the order becomes meaningless. Mum's position was also straightforward. She said she hadn't stopped contact. She said she had encouraged the daughter. She said she spoke positively about Dad. She said she'd got her ready. But when the moment came, the child became upset and refused. And Mum said, I cannot physically force an 8-year-old child into a car. That is the emotional centre of the scenario. Because most people can imagine that scene, a child crying, a parent at the door, another parent waiting outside, everyone tense, everyone watching what the other person does. And the parent with the child is being judged on whether they've done enough. Mum said she had done everything she reasonably could. She said forcing the child would cause distress. She said it would make future contact harder, not easier. And she said the court needed to understand why the child was refusing before punishing anyone. The real issue. This is why the scenario is not as simple as there is an order so Dad wins. And it's not as simple as the child says no, so contact stops. The real question is, why is the child refusing? And what has each parent done about it? And this is where the court has to focus. Because a child refusing contact is rarely the end of the discussion. It's usually the start of the investigation. Common myth is that children decide. And this is where we need to deal with that very common myth, because a lot of people think that the child gets to decide. They do not. Not in that simple way. An 8-year-old child does not have a legal veto over a court order. The court is not usually going to say, well, she said no, so that's the end of it. Especially when the order has only recently been made. Especially where the arrangements had been working for 6 months. And especially where the child is still quite young. Child's wishes and feelings matter. Of course they do. But they are not the whole scenario. On my Facebook group, quite often you will hear people say that their child's views were taken conclusively. But the truth is somewhere in the middle. It's a range of factors. The court does listen to the child. It does not hand the child the gavel. That's the difference. Common myth number 2 is that the resident parent must force the child. But there is another myth at the opposite end. Some people think that because there is a court order, the parent the child lives with must make contact happen no matter what. That is also too simple of an explanation. The court expects effort. The court expects support. The court expects encouragement. The court expects the parent to prepare the child properly. But the court does not usually expect a parent to physically drag a distressed child into a car. So the difficult part is the grey area in the middle, and family court is full of grey areas, as we know. What counts as encouragement? What counts as pressure? What counts as a genuine refusal? what counts as a parent quietly allowing the refusal to happen, and what counts as a parent actively creating the problem. These are not always easy questions. Enforcement proceedings, then, the two-stage test. Now, because Dad was asking for enforcement, the court had to think about this in a slightly different way. Dad wasn't just saying, I am upset that contact hasn't happened. He was effectively asking the court to enforce the order. And enforcement has its own structure. In simple terms, there are two stages. The first stage is whether the order has been breached. And that has to be proved beyond reasonable doubt. Now, you might be thinking that's the criminal standard of proof, beyond reasonable doubt. However, that is what is used for this particular test in enforcement. So even this is family court. The court is being asked to make enforcement findings. The court has to be sure that the order was breached. Not that it probably was, sure, beyond reasonable doubt. And that's why they use that. So the court starts by asking, was there a clear order? Did the order require contact to happen? Did contact fail to happen? And was that a breach of the order? If the answer is yes, then the court moves to the second stage of the test. The second stage is whether the parent had a reasonable excuse. And that is decided on the balance of probabilities. That is the civil and family law standard. In other words, is it more likely that the parent had a reasonable excuse for the failure to comply than they didn't have a reasonable excuse? Balance of probabilities sits therefore at around 51% sure. Whereas in my mind, as I always tell my clients, beyond reasonable doubt really should be about 90 to 95% sure of something. So the court might say, yes, the order was breached because contact didn't happen. But then the court still has to ask, did mum have a reasonable excuse? And that's where scenarios like this become difficult, because mum's reasonable excuse was not, I forgot. It was not, I changed my mind. It was not, I didn't like the court order. Her position was, the child was distressed and refusing, and I could not reasonably force her. Now, that might be a reasonable excuse or it might not. It depends on the facts, because a parent cannot simply say the child refused and expect that to automatically be enough. The court will want to know what the parent actually did. Did mum pack the bag? Was the child ready? Was the child told clearly that contact was happening? Was dad spoken about positively? Were adult issues kept away from the child? Was the child reassured? Was there a calm routine? Was there a plan for handover, or was the child effectively allowed to decide? Those are very different scenarios. The key line is this: breach is one question, reasonable excuse is another. So now you know the enforcement test. Has your answer changed? Would you say the order was breached? Would you say mum had a reasonable excuse? Or could you say the court still needs more information before it can answer either question properly? Because this is exactly why enforcement applications are not always as straightforward as they sound. There's also a huge difference between passive encouragement and active support. Passive encouragement is, you can go if you want. Active support is, you are going to your dad's this weekend. I know you feel worried, but dad's looking forward to seeing you, and I'll see you when you get back here. You'll have a great time. That distinction is massive, because a child should not usually feel that they're being asked to choose between their parents. That's too much responsibility and emotional pressure for a child. If an 8-year-old is effectively being told it's up to you whether you go, then the child may feel responsible for the entire adult situation. They may feel guilty about leaving mum. They may feel disloyal. They may worry mum will be upset. They may worry dad will be angry. They may simply avoid the whole thing because refusing feels like the only bit of control that they do have. And that's not fair on them. So when a parent says, I have encouraged contact, the court may want to know what that actually looks like, what that means, not just the words, the reality, because family court is very often about the reality on the ground, what is actually happening, not just what the order says, not just what each parent says should happen, but what is really going on in the hallway, on the doorstep, in the car, in messages, and in the child's bedroom while the bag is being packed. Because the court can write alternate weekends, but it cannot stand there every second Friday. It can't pack the bag. It can't manage the child's anxiety. It cannot make the parents communicate calmly. It cannot make a child feel emotionally safe. That work still falls on the adults. So when the order breaks down, the court looks at the whole picture. And that means it also looks at dad, because sometimes parents seeking enforcement focus only on the other parent. They say, Mum is not making it happen. And sometimes they are right. There are absolutely are scenarios where one parent says the child is refusing, but the real issue is that the parent has not supported contact properly. There are scenarios where a parent says all the right things, but their behaviour tells a different story. There are scenarios where the child is exposed to negativity, adult information, guilt, fear, or subtle pressure. There are scenarios where the child's resistance has been encouraged, directly or indirectly. And courts can take that extremely seriously. Because if a child is being allowed, encouraged, or influenced to reject a parent without good reason, that can be very damaging. But it's not always that. Sometimes there is a real issue in the other home. Sometimes something has changed. Sometimes dad is so focused on mum breaching the order that he has not really listened to what the child is saying. Sometimes a child is not rejecting the other parent, they are reacting to a particular situation. So the court may ask dad, has anything changed? Has there been an argument? Has the child had a bad experience? Are you listening? Are you adapting? Are you blaming mum for everything? Or are you also asking whether anything at your home might be contributing to this? This doesn't mean that dad is at fault. It means the court is trying to understand the whole picture. And that brings us to some new information. When the court looked more closely, the child was not saying, I hate dad. She was not saying, I never want to see him again. She was not making serious allegations that dad was unsafe. What started to emerge was something more specific. Dad had a new partner, and the child and dad's new partner did not get along. There had been arguments. The child felt uncomfortable at dad's house. Now, on its own, that does not automatically mean that the contact stops, not even close. Children often struggle when a parent starts a new relationship. That can be completely normal. It can feel strange. It can feel like their place in the family has changed. It can feel like someone new has arrived and taken up space that used to be familiar. And children don't always express that neatly. An 8-year-old is probably not going to say, I'm experiencing emotional difficulty adjusting to the changing dynamic at dad's home. They're 8. They might say, I don't want to go. Or, I don't like her. Or, I want to stay here. So the court has to be careful. A new partner is not automatically a problem, but a new partner can be part of the problem, especially if the relationship has been introduced too quickly, or the child feels pushed out, or if dad becomes defensive whenever the child raises it, or perhaps if the new partner takes on too much of the parenting role too soon, or if the child feels like dad is choosing the new partner over them. And this is a really common issue. A parent may think, my new partner is lovely, the child should just accept it. But that's not how children always experience it. A child could be polite. They might smile. They might say they are fine. But underneath, they may feel displaced. They may feel awkward. They may feel like they have lost their special time with that parent. And then suddenly the problem comes out at handover, not because the child has carefully analysed the issue, but because the child's reached a point where they cannot manage the transition anymore. That doesn't mean the new partner has done anything terrible. It doesn't mean dad has done anything terrible, but it may mean the arrangement needs handling more carefully. Timing matters. Sensitivity matters. Boundaries matter. The adults may feel ready to move on. The child may not be in the same place. Dad's answer to the new information. Dad's position was, well, she needs time to adjust. Mum is encouraging the objections. This is becoming an excuse to stop contact. And again, that's not a silly argument, because sometimes a child's complaint about a new partner can be amplified by the other parent. It can become, oh, you don't like going there, do you, because of her? Or you do not have to go if she is there. Or, I knew this would happen. And even if those comments are not intended to cause harm, they can harden the child's view. Mum's answer to the new information. But Mum's position was, this is the reason contact has broken down. The child is uncomfortable. Dad is not taking that seriously. She should not be forced into a situation that is upsetting her. And that is also not a silly argument. So this is where the court had 3 broad options. Option 1, enforce the order. The first option was to enforce the order. That would mean the court deciding that the order had been breached, that mum did not have a reasonable excuse, and that some kind of enforcement response may be needed. That might be a warning, it might be an enforcement order, it might be unpaid work in more serious cases, it might be a variation. It depends on the circumstances, but the basic message would be there is an order, you must comply with it. Option 2, to investigate further. The second option was to investigate further, which would mean the court deciding that there was not enough information to safely blame either parent. The court might want more evidence. It might want Kafkas involved. It might want to hear more about the child's wishes and feelings. It might want to understand what had changed. It might want to know whether this was a genuine difficulty, a parenting problem, or something more serious. Option 3, change the arrangements. The third option was to change the arrangements. That would mean the court deciding the order, at least for now, was not working in its current form. Not because dad should lose his relationship with his daughter, not because mum gets to ignore the order, but because the existing structure was failing and something more practical was needed to rebuild contact. So now you have the extra information. The child is not rejecting dad entirely. She is uncomfortable around dad's new partner. Mum says that explains the refusal. Dad says mum is using it as an excuse. What would you do now? What would you enforce? Would you order the existing weekends to continue? Would you say dad's new partner should not be present for a while? Would you order a report? Would you change handover? Or would you do something else? This is the point in the scenario where the decision becomes much harder. So, what did the court do? The court did not jump straight to punishment. The court accepted that there was a real issue to understand. The judge was not prepared to treat the child's refusal as the final answer. But the judge was also not prepared to ignore the fact that the child was distressed. That is the balance. The court did not say the child does not want to go, so dad loses his weekend. But it also did not say there is an order, so the child's feelings are irrelevant. Instead, the court focused on the underlying question: why is this happening? And what is the best way to repair it? The court accepted that mum had made genuine attempts to facilitate contact. That meant enforcement action against her was not appropriate on the evidence available. But that was not the same as saying contact could just stop. And this is a really important point. Not enforcing against mum did not mean mum had won. It did not mean dad had lost. It did not mean the child had decided the scenario. It meant the court was not satisfied that punishment was the right answer. But the court still had to deal with the problem, because the situation could not simply drift. So the court wanted a plan, not just blame, a plan. The arrangements were temporarily adjusted. Some time with dad would take place without the new partner being present. That was not because the court decided the new partner was a bad person, and it wasn't because the court decided that dad had done something wrong. It was a practical step, a way of testing what was really going on. If the child could spend time with dad comfortably when the new partner was not there, that would tell the court something. It might suggest that the relationship with dad was still intact, but the child needed a slower transition around the new partner. If the child still refused, even when the new partner was not involved, that would tell the court something different. It might suggest that there were wider issues. The court wanted to preserve the relationship, but it wanted to do it intelligently, and that is often what a good family court decision looks like. They're not always cinematic. They are not always dramatic. They're not always mum wins or dad wins. Sometimes the answer is we need to slow this down, understand the problem, and rebuild properly. Now, if you chose enforcement, I can see why, because there is a real danger in these scenarios. A parent could use the child's refusal as a shield. They could say, it's not me, it's the child. And if the court accepts that too easily, then court orders become weak. A parent who does not like the order could simply allow the child to refuse and then say their hands are tied. That would become a serious problem. But if you chose not to enforce, I can see why as well. Because punishing mum, if she genuinely could not get the child to go without escalating the distress, might not solve anything. It might actually make the child more anxious. The child might think, now mum is in trouble because of me. That can make the emotional burden worse. So enforcement is a tool, but it's not the only tool. The purpose of the family court is not simply to punish a parent for non-compliance. So, did your decision match the court's? Did you choose enforcement? Did you choose further investigation? Did you choose changing the arrangements? Or did you change your mind as the new information came in? Let me know in the comments, because this is one of those scenarios where reasonable people really can disagree. And I would be interested to know where you draw the line. When does a parent saying the child refused become a reasonable explanation? And when does it become an excuse? Because that line is one of the hardest lines in family law. Next time we move to a different kind of dispute. A mother wants to take the child abroad for a holiday. The father objects. Not because he says the child will be unsafe, not because he fears abduction, but because the holiday clashes with his court-ordered time. Mum says it's a special opportunity. Dad says a court order is a court order. So who should the court side with? The parent who wants the holiday? The parent whose time will be lost? Or should the court find another solution? That's the next scenario. Until then, you be the judge.